Hi, I'm Avlin and I'm an intern with LEXIS and Company, and today I'm going to discuss the topic of international conventions of intellectual property rights. So, I just want to brief you about that what all I'm going to discuss in this video is. We'll be talking about what are intellectual property rights and what are the treaties at international level, and so yeah, this is what we are going to discuss. And moving forward, before going to that what exactly is intellectual property right, it is essential to understand what is property rights. So we all know that property can be owned by any individual, company, government, charitable institution, or by a religious institution. And property rights are the use of that property either to transfer or to earn money or to dispose of, etc. So therefore we can say that intellectual property right is a right of property uh, for the ownership of that property, which is not of tangible nature and is based on one's intellect. Moving further, we can divide intellectual property rights into basically two categories. One is copyrights and the other one is industrial properties, which includes patent, trademarks, geographical indicators, patents I've already said, and further industrial designs, etc. So now let's move forward and see what basically are the international conventions on intellectual property rights. Intellectual property rights or laws are always in a nation's national nature, but however there are many conventions and treaties under which nations agree to provide a minimum level of protection of IP, intellectual property, to protect intellectual properties created by the nationals of their countries. So, WIPO, that is World Intellectual Property Organization, administers over 20 treaties and conventions for the protection of intellectual property. These conventions are related to registration and classification and protection of IP. So today we are going to discuss some of the conventions of intellectual property right. So to begin with, we'll be discussing UDHR, that is Universal Declaration of Human Rights. It was held in 1948. So UDHR is adopted by United Nations General Assembly in 1948. It consists of 30 articles, and these UDHR basically deals with the human rights. So individual human rights के साथ UDHR deal करता है. And further, Article 27 of UDHR that particularly deals with intellectual property. So let's see what does Article 27 says. So it says everyone has the right to freely participate in the cultural life of the community, to enjoy the arts and share in scientific advantages and its benefits. So this although it has not been written anywhere, but this implies to depict the existence of intellectual property rights. So moving further to the second convention is the Paris Convention for the Protection of Industrial Property. It was in 1883. So there was an international exhibition which was held in 1873 in Vietnam, but the participation was hampered by the fact that many of the foreign visitors were not willing to exhibit their inventions at that exhibition. Their inventions at that exhibition in view of inadequate legal protection. So again the conference was held in 1883 in Paris, and then it was named as Paris Convention for the Protection of Industrial Property 1883. In this, 11 states signed the Convention for the Protection of Industrial Property at this conference in 1883. So Article 2 and Article 3 of this agreement talks about national treatment, that is without any discrimination. And a concept of independent patent was also introduced in this convention, which means that if one country gives a patent, then there is no obligation on the other country to give the patent for the same thing. So this was what the principle was. So moving forward, we have Patent Corporation Treaty, which is also known as PCT 1970, and India became a member of this PCT, that is Patent Corporation Treaty, in 1998. This treaty for international cooperation is made in the field of patent. This treaty is complementary to the Paris Convention and is made for the members of Paris Convention. That is, only those who are members of the Paris Convention can be part of PCT treaty. The next treaty that we have is Berne Convention for the protection of liberty and artistic work, 1886. This convention is administered by WIPO. It was modified in 1971 at Paris. It is the oldest treaty in the field of copyrights, and the aim of this treaty is to protect in as effective and uniform manner as possible the rights of the authors in their literary and artistic works. Further, this treaty provides for the national treatment, autocratic protection, national protection, not dependent on formalities like registration, fee deposit, etc. It provides for independence protection. This treaty gave a rise to a concept of folklore, which means it gives right to the country if the author is unknown and there is a ground to presume that the work originated from that country. So although the word folklore has not been mentioned anywhere in the agreement of this convention, but it is implied with the it is being used as an expression for the said thing. So moving further, we have Universal Copyright Convention, which is UCC 1952. It was adopted in Geneva, Switzerland, developed by UNESCO, which means United Nations Economic, Social, Cultural Organization, as alternative to Berne Convention for state, who did not agree to the Berne Convention but wanted to be a part of the multilateral copyright treaty. So they were given the benefit under Universal Copyright Convention, UCC. So under UCC, copyright protection was provided for fixed renewable period, and for copyright it must contain a copyright notice and be at a copyright office. So further but TRIPS के आने के बाद, so when TRIPS came in the picture, Berne and UCC lost its significance. So this was the part 1 related to international conventions of IPR. We'll be discussing further some more treaties and some more conventions related to IPR in our second part. So thank you.